Good evening, everyone. Welcome to this webinar entitled Advertising Your Practice. My name is Alex Brownlee. I'm the CEO of EthiQal, also a healthcare actuary and supporting the healthcare system in sort of the last 20 years. On the topic for tonight, advertising certainly can be a useful way to reach your patients. However, it's crucial to ensure that advertising is not misleading and remains ethical. This webinar will navigate the legal and ethical responsibilities, aiming to provide you with valuable insights to ethically enhance your practice visibility and reach. But before we delve into that, let me just touch on some housekeeping to ensure a smooth and productive session. Firstly, the Q&A session, there will be one after the presentation. There is a Q&A button at the bottom of your screen. Please click on that and fill in your questions. We'll get to that at the end of the session, after the presentation. There are also some questions as part of the registration process, so we'll be dealing with that at the Q&A session too. The duration's advertised for approximately 1 hour, but I think that we won't, the presentation will probably be less than an hour by the Q&A session, depending how long that carries on. A recording will be made available on our website following this. Just give us a week just to get that sorted. There will be an opportunity to provide us some feedback in a survey fashion at the end of the webinar following the Q&A session as it ends. So please do give us feedback. Feedback is very valuable for us to improve for future sessions. There will be another session in June at least, and also allows us just to get some insights into what topics would be of interest. This webinar is accredited for 2 ethics CP points. Please, we are relying on your accurate information, so ensure we've got that. We will submit this to the HPCSA on your behalf, and we will provide a certificate for your records evidence. Moving on to the 2 speakers tonight, it's my pleasure to introduce JP Ellis and Ethel Gordon. Ellis is our highly skilled legal professional in the EthiQal team. Has over a decade of experience in medical malpractice and professional indemnity insurance. JP heads up our legal team as well as the claims function. JP holds degrees in business and law, is a licensed attorney, has a right to appear in the High Court. And prior to joining EthiQal back in 2017, JP served as a litigator at a top law firm specializing in medical malpractice defense. It's also a great pleasure to introduce Ethel Gordon, part Cloud & Co. For the last 2 decades, his primary field of practice has been in negligence. In that capacity, he's represented 100 legal and related practitioners in various areas. And certainly, Ethel is widely considered a leading ex-medical malpractice. So with that, welcome to everyone, and I'd like to hand over to JP and Ethel. Thank you.
Thanks, Alex. Thanks for the introductions. As the title of the talk suggests, we're going to delve into the topic of advertising, dealing with some of the ethical issues, as well as answering some of the common questions. So the way that Ethel and I will deal with this is that we're going to cover a number of different topics. We're going to first start off with some of the ethical and legal framework, but let me just share my slides. Okay. Ethel, can you give me a thumbs up if you can see the slides? Cool. Yeah, so the content of the talk is really going to center around the legal framework and then the do's and don'ts about advertising your medical practice. Then we'll touch on a number of different areas like websites, social media, patient testimonials, the involvement of influencers, etc. And then we'll close it off with some Q&A. During the presentation, we will touch on some examples of some issues where we have some concrete examples that can helpfully demonstrate or illustrate the point. So I'm going to hand over to Ethel now, who's going to cover the first part, which is the ethical advertising and the legal framework. Ethel, you're on mute.
Thank you. Thanks, JP. Thank you, everyone, for taking the time to join us. Hopefully you'll find this rewarding, have some of the questions you may have answered, and certainly take some learning away from it. So suppose the first question we must ask is, why is it important that advertising in relation to the healthcare professions must be ethical? And if you think back to the sort of genesis of medical and dental ethics, it's the two principles of beneficence and non-maleficence. And essentially, what the ethical framework and legislative framework around advertising in relation to healthcare practices is aimed at is preventing the exploitation of patients. We'll talk a little bit more about that later. Preventing harm being caused to patients, to protect the reputation of individual practitioners, and also to protect the image of the professions. So those, broadly speaking, are the four aims that the ethical guidelines which regulate advertising in the professional space aim to achieve. You can get the next slide, JP. So as usual, we operate within a legal framework, and equally as usual, there isn't just one law that we can go and look at in the statute books, which gives us all of the legislative provisions applicable to advertising in the health professions. Also, as usual in South Africa, it's spread all over in a mixture of legislation, which is of broad application, legislation which is of specific application, some regulations promulgated under the Health Professions Act, some provisions of the Medicines and Related Substances Act, and then the ethical guidelines. But if we just take a broad view of it and we start on the outside and work our way inwards, we have a piece of legislation called the Consumer Protection Act, which everyone will more or less be familiar with by now. It's been with us for more than a decade, and it has an impact on every aspect of life. Patients, like shoppers in any one of the big retail stores, are consumers in terms of the definition applied to that notion in the CPA, and they are entitled to the protection afforded by the CPA. Now, Section 11 of the CPA regulates what we've come to know as direct marketing, and it's also known as cold canvassing. It's recognized that this form of marketing creates a broad inroad into people's rights to privacy, which we also know is guaranteed by the Constitution. So from the perspective of ethical advertising in the professional sphere, I want to say to you that consider direct marketing as a no-go area. In almost all instances that I can think of, it will be considered as being unprofessional and unethical. The following provisions which we need to have regard to then are sections 29 and 41 of the CPA, which deal with the issues of fraudulent, misleading, false, or deceptive marketing. Now, as you probably know, those are all frowned upon by the Act, and they are prohibited. And there are consequences for retailers or suppliers who employ those marketing techniques, and they're provided for in the CPA. So, as a sort of checklist with regard to what you intend to publish as marketing material, you should consider the following. Number one, if you are making any form of claim, can you demonstrate that that claim is true? If not, then in all likelihood, the advertising will be regarded as being unprofessional. You want to avoid any form of marketing which is associated with, in the minds of patients, or is done in conjunction with product suppliers. You do not want to be seen to be promoting product A in preference to product B in the market. And a little bit later on, we'll get to dealing with that in more detail. A further aspect which you want to avoid in this regard is the co-branding of events with suppliers and product manufacturers, such as seminars, such as literature, except in certain limited circumstances. If you receive any assistance or sponsorship or funding in relation to any of these advertising or marketing activities, then obviously you have to be transparent about that and make disclosure. And what's not on this slide, but which ought to be patently obvious, is do not engage in marketing which is false, misleading, fraudulent, or deceptive, because that will be unprofessional. Next slide, please. Okay, so we've looked at the CPA and we know what it says. So now we narrow in our focus and look at what is particularly applicable to the health professions. Now, you'll all be familiar with the Health Professions Act, and most of you will know that in terms of the Health Professions Act, the minister can promulgate regulations, and he has, pursuant to that power, from time to time promulgated and updated a set of regulations which used to be contained in the old booklet number 2, published by the HPCSA, but it's now just called the EthiQal rules on its website. What's important to note is that even though we have more than 15 booklets of ethical guidelines, it's only those that were contained in booklet 2, which we are now going to look at, which were actually promulgated in the form of regulations, and therefore they have the force of law. So if we look at EthiQal Rule 3, some of you will be familiar with this. It's a change from what the old regime was, and it sanctioned the use of advertising and marketing by practitioners. So you can read the rule in your own time, but it basically says, taking a departure from the past where advertising wasn't allowed to a position now where advertising is allowed, it will be permitted, provided that it's not unprofessional, untruthful, deceptive, or misleading. And this is a specific addition, or causes consumers unwarranted anxiety that they may be suffering from any health condition. That latter part feeds into the notion of patient exploitation and why that must be avoided in any form of marketing. You will also have picked up that the use of the words untruthful, deceptive, or misleading is not dissimilar to what we saw in the CPA. So the regulations actually carry through the same themes of prohibition that the CPA contains in respect of all suppliers and retailers of services and goods to consumers. And then the second part of the rule is, even though you can advertise, even though you can tell people about your services, even though you can market your skills, a practitioner will not canvass or tout for patients or allow canvassing or touting to be done for patients on his or her behalf. Now, I think everyone will be quite familiar with that rule. That has always been the position, and I don't see that rule being relaxed at all in the future. So what we see is that EthiQal Rule 3 mirrors what the CPA says, but it adds the requirement of professionalism. Now what is that? To me, that means that whatever you use as marketing must not demean the profession or lower it in the esteem in which it is held by the public. So don't do anything tacky. Don't do anything that makes people think less of the medical profession than they ought to. Don't do something which is sensationalist. Avoid dramatics. And don't use advertising tricks and campaigns which are designed to attract attention. Whenever you see an advert or think of a way of marketing your services, always ask yourself, will this be deemed as professional, or will it be deemed as demeaning to the medical professions? And the test for that, the best test for that, is ask yourself, does what I'm saying or what I propose to say alter the way in which the profession will be viewed by members of the public? Thanks, JP. Next slide. Okay, we then also have to look at EthiQal Rule 19, which again forms part of the ethical rules, which are regulations. And this is the prohibition against the use of secret remedies. That's the first part, and it's not that important for present purposes, save to highlight that sort of marketing claim as being one that will be regarded as sensationalist and unprofessional. But what's important is sub-rule B. And here it comes back to the issue of being able to demonstrate that what you are saying is true. You'll remember we touched on that theme a little bit earlier, And here it comes through expressly in Ethical Rules 3B. If you are going to advise a patient or the public or the market that there's a particular technology, apparatus which you use, which can fulfill a particular purpose or do something, then you must be able to demonstrate that it can do what you say it can. And again, that is perfectly in alignment with the CPA requirement of truthfulness. So the rule to take away here is only claim that which you can prove. Thanks, JP. Going further, we then find Ethical Rule 23, and I'll leave you to read that in your own time. And you'll see that they seem to contradict each other. That's sub-rules 1 and 2. Sub-rule 1 says, don't sell, market, advertise, promote anything, which amounts to selling medicine or medical devices to the public. Sub-rule 2 then says, you cannot engage or advocate the preferential use or prescription of any medicine or medical device, which, save for the money that you get for such preferential use, would not be clinically appropriate or the most cost-effective option. And that's really the important point. If what you are proposing to prescribe to or dispense to your patient for that matter is clinically appropriate and the most cost-effective option for the patient, then by all means, you can do what sub-rule 2 says. Again, it feeds into the theme of being able to prove what you claim in your advertising or promotion of a particular product or device. Thanks, JP. Sub-rule 5 of Ethical Rule 23 says, as an exception to that sub-rule 1 that says you can't sell, market, promote, distribute, do anything with respect to medicines and so forth, and devices and so forth, despite that, you can prescribe or supply medicine or a medical device, provided that you diagnose the patient as a result of a personal examination or as a result of the report of another practitioner who treated the patient. And 1, that medical device or medicine is clinically indicated, taking into account 2, the diagnosis and prognosis of the patient. And again, here we get back to proving what's been claimed and affords the best possible care at a cost-effective rate compared to everything else on the market, and provided further that you inform the patient that there are alternatives available in the market. So what it says is you can sell, promote, supply medicine to a patient if it's based on a diagnosis which you've made, if it's in keeping with the patient's prognosis, if it is the best possible care being offered to the patient at a cost-effective rate when compared to everything else in the market, and the patient is aware that there are other alternatives available to him or her. Again, what I use this ethical rule to illustrate is that it gives life and meaning to the principles of transparency, truthfulness, and the principle of beneficence, being that the interests of the patient are supreme. Thanks, JP. Okay, then we've got booklet 11, which, if memory serves, is the booklet in relation to perverse incentives. JP will correct me if I'm wrong. But basically what this says in relation to the use of a particular health establishment, a registered medicine, a complementary medicine, anything else of that nature that unfairly promotes the practice of a particular healthcare practitioner or facility for the purposes of financial gain or other valuable consideration. You must not engage in advertising that. You must not engage in that behavior. But the test here is unfairly promote. So again, returning to the principle of truthfulness and being able to prove what you claim. This means that you can promote the use of something, medicine, for example, provided that you can justify that it is cost-effective and care appropriate for the patient in that particular setting. Okay, JP, thank you. Finally, if I recall the slides correctly, can we have a look at the Medicine and Related Substances Act? Now, this is an interesting issue, and maybe it's something we can deal with in the Q&A if queries come up on it. But in essence, and I've summarized what Section 20 of that Act says. Basically, it prohibits the publishing of false advertisements concerning medicines, devices, or IVDs other than that for which the medicine, devices, or IVDs was approved by SAPN. So you can't claim the efficacy of medication other than for the purpose stated by SAPN. But what about the off-label prescription or use of medication, which is commonplace? And I think that would be justifiable on the basis that it is capable of being proved, of being able to do what you say it can. And I think that might be the final slide, JP. Yeah, thanks. I'm going to hand over to JP now.
Cool. Thanks, Ethel, for the background to the legal and ethical framework which governs the advertising of your medical practice. So now we're going to touch on a couple of things of what you should avoid when advertising. Some of this might seem obvious, but I think it's important to just restate. And the point that Ethel also made, I think, is always the starting point. The question should always be, does this bring the profession into disrepute? So that should always be the starting point. Dealing with false claims and misleading information. Practitioners should refrain from making inaccurate or false statements about their qualifications, expertise, or the efficacy of their treatments. False claims can mislead patients and compromise their health decisions, and advertising should not present information in a way that could mislead or confuse patients. So this includes using language that implies unrealistic outcomes, omitting important details, or creating a false sense of urgency. Also, we need to be mindful of Booklet 2, Rule 25, relating to the reporting of unprofessional, illegal or unethical conduct on the part of colleagues. What happens sometimes is that colleagues will sometimes malign one another in a number of ways, and that also has a bearing on the way in which you advertise your practice, saying that you're the best in the market, sort of impugning the dignity of your colleagues by making certain assertions. On the right over here is just an example of an advertisement that makes some unrealistic expectations with regard to a fertility clinic who advertises a specific treatment as a guaranteed solution for infertility without mentioning the complex factors involved in fertility without any side effects. I mentioned comparison with competitors. Unsubstantiated statements, I think that's also quite obvious, but just to mention that unless it's expressed by patients in their testimonials or reviews of your practice or services, it's best to avoid using words like the best, top, world famous, most qualified, etc., because this can also be misleading to patients who may be trying to make a choice regarding their caregiver. Can also have a negative consequence if the service does not meet the expectation of the patient who reads such statements. More importantly, you should provide your patients with details about your practice, your qualifications, experiences as a doctor, the facility that you operate from, actual patient testimonials and expectations, because it's best to keep the information that you use to advertise generic or factual rather than subjective. Guarantees and promises. This also has a bearing on your consent. So be careful of the statements and the guarantees or undertakings that you make in your advertisements, because although you might in your advertisement make certain claims obviously that will have a bearing on what your consent form says, because if there is an adverse outcome or some unexpected consequence that follows, and it becomes an issue, let's say in litigation down the line, what tends to happen is that they'll consider your consent form and the claims that you made as part of the consent process against the claims that you made in your advertisement. So always be mindful of that.
Yeah, JP, if I can just jump in there.
Sure.
Before you send whatever advert you want to send out to your website publisher or host, put the consent form next to it. Read the contents of the two documents opposite each other. Look out for contradictions and ask yourself this question. If I was cross-examined on the differences between these two documents, what would that look like? Would it be a car wreck or would it be fine? And you'll pretty soon get a sense of whether or not the two documents work with each other or against each other. Thanks, JP.
Yeah, 100%. Thanks, Athol. Then lastly, exploitative practices. So to mislead patients is to exploit them, to give them a false sense of security when they face uncertainty is exploitative. To increase the anxiety to make them more likely to undergo a particular treatment is exploitative. So we've now touched on what to avoid. Let's touch on social media, because I know that is an issue that many practitioners have concerns about and have a lot of questions relating to. So what I tend to say to a lot of the more older practitioners who don't use social media is that even if you don't use that form of communication, it's important to understand that in most cases your patients use that. So that's something important that you have to set in, because I've had practitioners in the past who said that they don't have these Google pages where they actually advertise your business, or if you search on Google Maps, you'll actually pick up certain businesses or practices. But it doesn't have to be set up by the owner or the business manager. Any person out there could actually create a Google business profile, just to mention that they had a service from your practice and give you 1 star or 5 stars. But that's something that's a reality. Patients will engage with you on social media, whether you use it or not. So it's always important to have a good understanding of what's entailed when it comes to the usage of different platforms. Social media ethics, that's contained in booklet 16. It's a new booklet that was published in 2019, if I'm not mistaken. And as I mentioned, it's a good tool for advertising your practice, but you need to exercise caution, because as Athol mentioned, you operate in a very strict ethical and legal framework when it comes to your profession and ethical standards. So always exercise a level of caution when using social media, but keep in mind that there's no impediment, there's no outlaw or impediment for you to use social media in your day-to-day practice. So I also believe that it's probably the most significant development in terms of you interacting with patients in modern medicine today. So it's useful to have an understanding. And as I said before, the first question is, will this bring the profession into disrepute? That should always be the starting point when you're trying to navigate your way through a particular mode of communication, whether it's with patients or the public. So the first point is to avoid bringing the profession into disrepute. We've seen examples like that in the past. I've included an image here of an article from the Mail Online. These type of scenarios are quite common, actually. Surgeons taking photographs during surgery or other forms of treatment or care, people making unsubstantiated negative comments about individuals or organizations, practitioners making informal or derogatory comments about patients, or making comments that can be perceived as racist, sexist, homophobic, or otherwise prejudiced, even in jest or as satire. The other important thing to always keep in mind is your professional boundary. There needs to always be a clear differentiation between your personal and your professional profile. I tend to suggest to practitioners that they need to have if they choose to advertise on social media, to have two separate profiles, one being your professional one where you post things relating to your practice information or healthcare information, and then your personal one where you keep private between you and family and friends. Because sometimes the lines between the patient and doctor relationship can get blurred if you engage with a patient on a personal level or in an informal setting. So that's always crucial, because sometimes you might be privy to information that you otherwise wouldn't have had in a normal clinical environment. So be careful of that. So avoid personal, romantic, or overly informal interactions. So as an example, consider a doctor who shares personal details about his vacation and family life on his professional Facebook page. This breaches professional boundaries by blurring the lines between his personal and professional life. So that should be avoided. The next one is confidentiality and privacy concerns. I think that's quite obvious. Respecting patient privacy is paramount, and practitioners should avoid using or sharing any patient information, images, or details that compromise confidentiality. Consider an example where Dr. Sitoli, for example, posted a photo of a unique medical case on Instagram. Although the information is kept anonymous, this will breach patient privacy and violates confidentiality. Dealing with patient queries, that is also a common feature nowadays. I suppose that and managing online patient reviews is something that we see often together, where patients will query things online, whether it's Facebook groups, or I think it's ratemd.com. You get a lot of these type of online patient review websites where patients will actually post the experiences of their treatment or the advice or just complaints. So one has to be alive to that. And engaging with patient queries on social media requires sensitivity. Firstly, because you've got a unique situation where for patient confidentiality, you can't respond in the normal way that other service providers would. So avoid providing any specific medical advice without proper context, and direct patients to private channels for more confidential discussions. So what you could also do is you could respond and invite the person to contact you directly so that you can deal with it. If you are responding to online reviews or patient queries, try to give a very specific or unique response. Nobody wants to see a generic response to every patient query online. And as I said, invite them to contact you is a way of showing that you care about your patients and that you're genuinely interested in giving them a good service. So,
Yeah,
as an
JP,
example, yeah, Ethel?
JP, sorry if I can just jump in there. My advice on those is offline, offline, offline. Take those queries and responses offline. It's the only way of ensuring confidentiality, because even if at that stage the patient is using a fake name or they're anonymous, you don't know if in the forthcoming exchanges the patient is going to reveal information which then makes it capable for others to identify who they are. And then suddenly you're caught in a breach of confidentiality. So that response, I'm sorry to hear of your query, or I was interested to read about this. Please, will you contact me at the practice at these details so that we can discuss it? That's critically important. Thank you.
Yeah, 100%. Anonymous complaints are also something prevalent nowadays. So it's best to avoid responding to those type of complaints. In some cases, one is able to identify those patients, but at all costs, try and avoid any response to patient or anonymous complaints or queries online. Also, try not to be too defensive when you're responding to a negative comment. It just gives off a bad taste. You are meant to be professional, show that you have concern for patients. So when you are inviting them to come and see you, try to do it in an empathetic way. So I was going to give an example of a patient who comments on, for example, and just to use the name Dr. Dube's Facebook post describing symptoms and seeking advice. Dr. Dube responds with detailed medical advice. He violates the principle of patient confidentiality, and he provides specific recommendations without a thorough examination. So that would be a no-no. Hopefully that doesn't happen to anybody that's listening to this talk. Responsible content sharing. When sharing content, you should ensure that it's accurate, evidence-based, and serves an educational purpose. I've mentioned the managing of the online patient reviews. There are some techniques one could use to remove negative online patient reviews, but that's only in the case where it is defamatory or untrue. If the person's just expressing their experience, then you'd have a hard time trying to remove those. In most cases, it's better to just leave sleeping dogs, deal with that. Also, when we talk about testimonials, I'll mention another technique to sort of counter negative online reviews. Maintaining professionalism, advertising services responsibly. I think those are all quite obvious. I'll skip through that. Touting and canvassing. Ethel mentioned that earlier. So touting involves drawing attention to one's professional goods or services by offering guarantees or benefits that fall outside one's scope of practice. The booklet talks about situations where a practice might invite members of the public into their rooms because they're offering free Wi-Fi. So that's an example of touting. Canvassing involves the promotion of one's professional goods and services by drawing attention to one's personal qualities, superior knowledge, quality of service, professional guarantees, or best practice. So think of the example of saying that you are the best surgeon in the country. That could be considered as canvassing. And then lastly, a disclaimer. It's always useful to have a disclaimer when you are using a social media profile, indicating that the views expressed are your own and not those of the health profession or the establishment that you represent. But of course, that doesn't absolve you from the ethical rules. Now we're going to touch on websites. Most practitioners use websites. I think it's almost a prerequisite for having a successful business. And the importance of websites are obvious. Even in other spheres of business, they play an important role in enabling customers to get information about your services and to contact you. So there's a couple of points to consider when having a website. The first one here is an important one, and one that I need to emphasize is that if you are setting up a website, make sure that you contract a professional website designer, not just for aesthetics, but also that you have a contractual relationship. And I'll illustrate the point with an example. We had a situation some time ago where a practitioner had a very aesthetically pleasing website with very high quality, high resolution photographs. He then received a letter from a German law firm who was representing a professional photographer. And what they had claimed is that the photographs on the website were owned by their client, and it infringed on his copyright of those images. So what you had is a situation where they were claiming damages now for the unlawful use of the images. And that was quite an issue because there's actually I wouldn't say a syndicate, but there's actually businesses that operate on this basis where they have these web scraping tools. They search the internet looking for their clients' photographs. And if you haven't received a proper license to use those images, you could fall foul of that copyright infringement. So fortunately, in that case, we were able to get it resolved. But that is a lesson that if you are using a top-notch professional website designer, ensure that you have a contract in place. And we would strongly urge you to ensure that that agreement has a clause that will indemnify you for any damages flowing from any infringement of any intellectual property. as well as a guarantee that the website designer has made every reasonable effort to ensure that the material is free from any IP rights and it's subject to appropriate license or use. If, however, you don't have a contracted service provider, then you need to check for licenses and permissions before using free resources available on the internet. And lastly, you can send a request to the author asking for permission, because in the world of social media content creation, crediting is a must. So as long as you credit the owner and you've asked for their permission, then you won't fall foul of that. Adequate security, I think that's a given. You need to ensure that you have appropriate security for your computer system, email, domain, appropriate hosting of your website. Because it could be that without those securities in place, you could be the victim of phishing, hacking, ransomware, you name it. Patient friendly, yeah, your website must be patient friendly because they are your consumers. And where you advertise, for example, surgical invasive procedures, you need to have a warning in place to explain that those procedures carry a significant risk, that they perhaps require admission to a day clinic, day hospital, or a hospital for a longer stay, or if it's elective procedures that will require more than local anesthetic or sedation, and ensure that the warning is clearly visible. Also, I've seen some very good websites where patient educational information is available on the internet, on the website, as well as the informed consent forms. Now, this helps tremendously when there is a dispute or an issue later down the line. We've seen a number of cases where consent features, or that's an issue in dispute, and one has to prove that there was a clear informed consent process that took place. Having these patient-friendly educational information on website, as well as your informed consent forms, just helps with that defense. It helps to demonstrate that you've given the patient every opportunity to consider their options and to make an informed decision-making with regard to their treatment or procedure. Scheduling consultations, a lot of good websites have that feature where you're able to make contact with a practice and schedule your consultation. Make sure that you have up-to-date contact information. Make sure that you regularly update your website. And also in terms of POPI, you should have a privacy statement. So make sure that your website has that. Professional fees, I think it's useful to set out what those fees are, whether you charge above tariff or whatever your arrangements are, or that you're not within a particular network, but make at least some of the professional fees available on your website. I did mention be careful of the images that you use, but also an interesting question that came through as part of the registration, and something that I've been thinking about for a while now, is the use of SEO. For those of you that don't know, SEO is search engine optimization. Basically, search engines like Google, Bing, Yahoo, they help users search the internet for relevant information using keywords. And a search engine optimization tool uses their own proprietary algorithms to index relevant information which corresponds with those keywords. So what typically happens is that companies or businesses will use a number of keywords to help the ranking of their websites, because obviously the websites that display first on search results are the ones that consumers go to first. So what sometimes happens is that website providers or website owners will use keywords that are linked to a competitor, like trademarks or even just their names. And it's been a question for a while now as to whether or not that's legal, or if it breaches any ethical requirements using a competitor's trade name in your search engine optimization. I don't necessarily have the answer. I've tried doing a bit of research, and Alec and Ethel and I were chatting about it as well. So it's a tricky one, but there tends to be a difference of opinion. And I've seen some judgments where it can go either way. So the law is not clear on the issue, I'm afraid. And there are judgments that I've said is diametrically opposed. However, it's unlikely that there'll be a significant legal risk using a competitor's trade name in an SEO. Because a lot of the time, these SEO works with functionality in the background. So it's all back-end things that consumers don't necessarily see. So from that point of view, it's probably okay, probably not going to be significant legal risk in using a competitor's trade name or using keywords that might be linked to a competitor. But I would rather err the side of caution and say don't use it. But if you are, the law is unsettled on that as far as I'm aware.
JP, if I can come in here with my conservative grey hair, and firstly, just clarify the SEO issue. As I understand, maybe if I give my lay explanation of it and understanding of it, it'll be more accessible to the viewers. So when you set up a website on a particular domain, often the platform provider offers you an option of subscribing to an SEO service or a button and something that you pay a bit of a premium for, but it guarantees better website hits, more results, and so on. And if you go ahead and choose that option, what gets done in the background by the algorithm is, as JP says, look for keywords that are associated with what you do and the products you are promoting. And it may use trademarks, like dental may use Colgate. And the effect of that is when somebody then uses that particular search engine to look for Colgate, at some stage your website will pop up. And I think that although the law is not settled in the normal commercial sense, in the sense of if a competitor of Colgate does that, is that going to be ruled unlawful by the law? Maybe, maybe not. I think if we are conservative in our approach and we say, understand that the ethical guidelines say that not only must it be truthful, not misleading, all those, but it must be professional as well. I'm just concerned that that umbrella is wide enough to be able to squeeze under the use of SEOs, which give you an unfair advantage. And again, it's the comparative thing. So, yeah, be careful.
100%, yeah. Yeah, be careful with those. It's probably not going to be settled anytime soon, but just so that you're aware of that. So thanks, Ethel. Now we're going to touch on patient testimonials. So using testimonials can obviously be a powerful tool for building trust and credibility for practice. So while testimonials can be powerful, practitioners must be cautious not to manipulate or present them in a way that misrepresents the typical patient experience. So testimonials should be genuine, and any claims made within them must be accurate and supported by evidence. So we've just provided a few guidelines on what to use when soliciting testimonials. The first, and I suppose from our point of view, obvious one, is to obtain express written permission. So before using any patient testimonial, make sure that you have a signed written consent from the patient. Clearly explain how their testimonial will be used, where it will be published, and if their name will be associated with it. Don't reveal sensitive patient information. It would be useful to show the patients examples of other testimonials that you've used in the past and include this in your consent form. Ethel, is there anything you want to mention on this?
Yeah, JP, I would just err on the side of always making the testimonials anonymized, so that the patient can't be identified, and put a note at the bottom of the web page where the testimonials appears to say the real patient's identity is not being used. It's a fictitious name to protect their privacy. The reason for that is that's the testimonial we get on Tuesday. The following Tuesday, something happens in the patient's life and they no longer feel the same way. Now it becomes an issue about I've been identified and I'm no longer happy, I no longer endorse that. And you don't want the question of confidentiality to enter into that debate about whether you can still use it or not after they've changed their mind. So just remove it by maintaining confidentiality.
Yeah.
Thanks.
The second guideline is to deal with any privacy issues. So ideally your consent, where you obtain the written permission from your patient to give you that testimonial, that should be included in the patient take-on form. So when the patient is first consulting with you and they're filling out all the forms, etc., and payment-related details, allow them to, at that stage, to give you that consent. Um, and always check that the information contained in those forms don't contradict your practice's privacy statement or your procedural informed consent forms. Then the third one, keep it anonymous. Disclosing patient information would mean revealing their identity, which is definitely not permissible on your webpage or social media pages. When discussing a patient case study, care should be taken to obliterate any mention of the patient's name and personal information that may render them identifiable. Provided that the patient has consented in writing and is comfortable, consider using the initials or a pseudonym in association with the testimonial, as Ethel suggested. And images of actual patients that have been used in some cases, particularly on social media, make sure that they're done with the written consent of the patient. That's also a sticky issue that we see often. Testimonials where they give you the testimonial, or they give you the permission to use the testimonial, but not necessarily the image. So make sure that your consent provides for that as well. It's always useful to highlight specific experiences, so encourage patients to share the specific details about their experience, such as the condition that they were treated for, the quality of the care that they received, and any noteworthy outcomes. Ensuring authenticity, using actors or fake imagery to portray a patient story or for patient testimonials, that's disingenuous, and it's unethical promotion of a medical practice. While it can be justified to protect the patient's identity on marketing material, it's using actors as representatives of actual patients is not the best way to expressly state the service that you offer or the testimonial of the patient. So try and provide a disclaimer to avoid any suggestion of misrepresentation if you are using an actor or fake imagery like AI, for example. Diversity, it's always better to have a diverse range of patients representing various demographics and conditions. Avoid misleading statements. I think that's obvious. Keep your testimonials current, so periodically update them to reflect your current state of your medical practice. This also helps to maintain the relevance and shows that your practice consistently delivers positive experiences. A disclaimer, I mentioned that earlier, but to have a disclaimer stating that the individual results may vary and that the testimonials are not a guarantee of specific outcomes, those are important. And that also helps to manage the patient's expectations. The last one here is something that's really at your discretion, but one could encourage patients to post their testimonials on one of those online review websites, because what sometimes happens is that a doctor will complain that their Google rating is maybe 5, and they've got 5 or 6 positive reviews, and here along comes another person and they give you a 1 star. And then following from that, you get a few 1 stars. So by having more positive reviews on these websites or these Google reviews, it just encourages a more balanced view of the service that you offer. So encourage patients to leave those reviews on reputable sites. It can enhance your practice's reputation, and it, as I said, counterbalances any negative or unfair patient reviews. Sometimes those reviews are unfair because they give a one-sided view, or they don't contextualize what actually happened. So that can be difficult. Then we're going to move on to the next item, which is influencers. I'm going to hand over to Ethel now, who's going to just touch on this topic.
JP, thanks very much. In the interest of time, I'm going to be brief on this. So the question is, should you use influencers? The answer is no. No and no again. If you publish a website and you're now hosting it for a while, don't be surprised if you are not contacted by an agency or a platform or an influencer who offers to attract more traffic to your website, who offers to get you more hits, get you more exposure, etc. I use the term influencer to describe that broad category of people, not just someone who wears fancy fashion clothes and promotes your product. You do not want to do that. Firstly, because that could be construed as touting. I think it is touting. It's also possibly canvassing. Secondly, why would you give control over the promotion of your services to someone else who's not bound by the same ethical rules as you are? And you could even have people who start promoting your services without your consent. If that occurs, you must disclose to your patients who bring this to your attention that this is what happened, and you must get a hold of the people who are doing it and get them to stop it as soon as possible. So avoid any form of use of influencers. Thanks, JP.
Thanks, Ethel. Just in terms of images in media campaigns, I'm going to skip a lot of this because, I mean, the same rules apply to the consent and the permission, as well as representing diversity in your images. The last point about avoiding sensationalism, just to maybe make the point that images must be not exaggerated. It must portray images that are more, I suppose, realistic, in line with unexaggerated portrayals of medical conditions or treatments. Maybe to give you an example, if you had to take a weight loss clinic's advertisement, which features a heavily photoshopped image of an extremely overweight individual alongside a skinny model, implying unrealistic and sensationalized outcomes, that obviously creates a false expectation and exploits the patient's insecurity. So I think that's quite an obvious one. Let's move on to gifts, discounts, and incentives. This is an interesting one. I'm going to try and deal with it comprehensively, but also quickly as I can, because I know we're sort of short for time. But this has brought up quite an interesting discussion that Ethel and I had. So Ethel, feel free to jump in. But medical practitioners are sometimes approached by a number of companies, whether it's sponsorship or drug companies, to use their products. So the question is, when you're sitting across the table from a practitioner and you see the pen that he's using or the calendar, or that obviously promotes a particular brand of product. So the question is whether or not those type of promotions are ethical, whether they should be used. But let's deal with the first one about the sponsorship of a practitioner's attendance at a conference. Now, accepting a sponsorship to attend a conference can be valuable for professional development, but a practitioner must ensure transparency and avoid arrangements that may compromise their clinical independence. One can imagine a situation where a pharmaceutical company sponsors a doctor's attendance at a medical conference on a specific condition. The doctor should disclose the sponsorship when discussing treatments related to that condition to maintain transparency and trust. Avoiding inappropriate arrangement and referral fees. So offering or accepting a referral fee can compromise the objectivity and trust inherent in the doctor-patient relationship. It can create a conflict of interest and prioritize financial gain over patient well-being. In the case of gifts, discounts, and incentives, while offering occasional gifts, discounts, or incentives may be acceptable, it's essential to exercise caution to prevent undue influence on patient decision-making. Inducements, including rewards such as gift vouchers or discounts for referrals, are problematic because they may encourage indiscriminate or unnecessary use of healthcare services. Excessive or inappropriate offers can be seen as attempts to gain favor or influence patient choices.
JP, before we move off that slide, just on the first point, the sponsorship. I remember many, many years ago, leading practitioners attending global conferences and being sponsored with respect to their flights and accommodation by pharmaceutical companies, and by certain grants by benefactors. And that booklet on perverse incentives, over servicing and the like, I think it's booklet 11, That has, as I now recall, completely prohibited that practice, except I think in an instance where the practitioner is going to attend as a speaker at the particular conference, in which event I think the HPCSA does allow the speaker to have the expenses paid by the promoter of the conference. So as far as I know, the guideline now is that you cannot have any form of sponsorship with respect to that sort of activity. Thanks.
Cool. Thanks. I think let's just touch on preventing patient exploitation, because I know we are running out of time. So medical practitioners should avoid exploiting patients' vulnerability, especially when offering discounts or incentives. Marketing practices should prioritize patient well-being and avoid creating pressure or exploiting patient fears. So consider the example of a doctor who advertises a limited time discount on a diagnostic procedure, emphasizing the urgency and creating a sense of fear if patients delay. This kind of promotion may exploit patients' anxiety and is ethically questionable. So now we'll touch on the penalties for breaching ethical guidelines. Ethel, over to you.
Yeah, thanks, JP. As you can imagine, if you've engaged in advertising or conduct which is regarded as unprofessional in terms of the Health Professions Act, you're likely to face disciplinary action in the form of a professional conduct committee inquiry, at which you could be found guilty of improper, disgraceful, or unworthy conduct, depending on the nature of the transgression of the ethical guideline applicable. Now, in 2010, the Minister promulgated minimum and maximum fines for different classes of offences in terms of the Act. Because some of you will know, let's put it that way, that in terms of Section 41, the HPCSA can impose a number of penalties ranging from a reprimand, a warning, to a fine, to a suspension, to erasure from the role. But then with respect to monetary fines, the Minister in 2010 promulgated regulations that said, for this type of offence, you will be fined a minimum amount of X and a maximum amount of Y. So on that regulation, the fine at the moment for an advertising-related instance of unprofessional conduct is a fine of between 2,500 Rand and 10,000 Rand. However, I was recently involved in a matter where, when it came to sanction, it was argued by the pro forma complainant that those fines stipulated in the regulation only pertain to fines imposed by the Committee of Preliminary Inquiry. And this is notwithstanding the express wording of the regulation, which says by a committee of inquiry, which refers to the Professional Conduct Committee. And the pro forma complainant in that instance, let's say for argument's sake, the maximum prescribed fine was 5,000 Rand, argued for the imposition of a 60,000 Rand fine, which we protested against because it's completely outside of the scope of the regulations. And the committee went ahead and imposed a fine of more than 5,000 Rand. So just be aware that though the regulations give you a particular amount, that's no guarantee that the Professional Conduct Committee is going to adhere to the regulations. And you may find yourself having to get that set aside and corrected by a court later. There's also a specific fine for touting. And you can see that penalty is based on whatever you've received or paid as an incentive. So depending on what the amounts are that are involved, that fine could be quite substantial. Remember also that one of the penalties, and I say it in quotation marks, for breaching these ethical guidelines is that you actually undermine the terms of your consent. And at defense, in a subsequent claim for damages, the court interprets the patient's consent as having been derived from a combined reading of the advertising statements and the consent. And then you could lose the protection that your consent would otherwise have offered you. The other thing to consider is the impact on your professional reputation of knowledge and awareness of this conviction and sanction by the committee. The hearings are still open to the public. in theory. Very few of them are held in person anymore, so they're held virtually. So I haven't seen a member of the public in any one of these for a while, but that could change. And remember also that the council publishes these findings on its website, and I think they're published in the Government Gazette, or certainly they used to be. So bear that in mind. Is it worth running that risk, is the question to ask. Thanks, JP.
Thanks, Ethel. Okay, so in conclusion, the ethical rules aims to strike a balance between allowing medical practitioners to inform the public about their services and ensuring that such advertising is conducted in a professional, truthful, and patient-centered manner, while also preventing aggressive patient solicitation. So doctors can use professional and patient-friendly websites and social media platforms that effectively promotes their medical practice online. Practitioners must exercise caution in their advertising of their practice to avoid false claims and misleading information. Providing accurate, evidence-based information ensures that patients can make informed decisions about their healthcare. These are essential for maintaining the trust and integrity of the medical profession. Thanks so much. Ethel, I think we'll move on to questions, but let's just allow Alex to join so you can.
Sure. Yeah, while we wait for Alex.
Yeah, can I see? So thank you very much, JP. Thank you very much, Ethel. It was a great presentation and examples, presentation, discussion. I will facilitate the Q&A session, so thank you everybody for sending some questions through. I will also touch on the questions that were sent beforehand. I'll jump to one little question, probably third one on the day, that sort of asked about JP being described as highly skilled and previously worked at a top law firm. So just to break the ice a bit, and ask, is that appropriate? So if I listen to JP and Ethel, I mean, certainly if I was the patient, JP was the doctor, and it's my testimonial, I think that is a slightly different prospect, because remember, I spoke about JP in that format. But JP, if I'm right, if you were the doctor and you called yourself highly skilled and a top, working at a top something or trained at a top training facility, you would need to be able to justify that. Am I right?
Correct. You don't have any control of how people introduce you or what they say. But certainly if you are using those type of adjectives to describe yourself, then that could be problematic, especially for a medical practitioner.
Great, thanks. So let me jump into some of the pre-sent questions, if I may. And I'll just, JP and Ethel, I'll just combine two or three that were touched on that was similar. So the question is, are advertising boards placed outside clinic walls permissible or ethical? And just linked to that, can you use the word clinic in the name or the branding? And a related question is, why is it not acceptable to have an advertising board away from the clinic? Even though it might be a nearby residential, but it's not at the clinic. Could one of you touch on that?
JP, just on that advertising board / publication and so on, way back in the beginning, the rule was to the effect that you could have a brass plaque present at the practice, naming the practitioner and their area of practice. So that was always the rule. And that was in line with the no advertising rule, certainly as I understood the context at the time. With the change in the views on advertising, and as we saw EthiQal Rule 3, one has seen a tendency for there to be advertisements placed for practices, for practitioners, and so on. And just because such a thing is placed on a billboard doesn't mean that that is regarded as ethical advertising. It probably means that no one has complained about it and the HPCSA has not considered it. You drew my attention to that ruling by the Medical and Dental Professions Board from about 2000, where they advise that the use of an electronic billboard off-site or even on the site of a particular premises would not be considered ethical advertising. Now, we couldn't find an ethical ruling on something similar or like a billboard more recently than that. But if that still holds good, then I think the issue of a billboard is problematic. And if I were asked by a practitioner, can I use a billboard on site or at the local high school down the road, which deals with the off-site question, my advice would be, why don't we write to the Medical and Dental Professions Board and ask them for a ruling or a directive on it? And that would be the easiest way to avoid trouble. So that's the billboard issue and my take on it. JP, I don't know what you think.
Yeah, no, that's 100%. So that comes from a resolution from the board in December 2000. Just on the topic or the question about whether or not you can use the word clinic in your name, your practice name. So booklet 2, I think it's Ethical Rule 5.3, prohibits the use of the word clinic, hospital in the name of your practice. So unfortunately, you can't do that.
Yeah, thanks, Ethel and JP. I think this is sort of an extension of that, and I think we've pretty much answered it. Ethel, I think you answered it, but the question says, can I brand and advertise on my company car? And is informative pamphlets allowed? I think that's slightly separate, but advertising on a company car, is that pretty much similar to a billboard?
Yeah, if I were asked that, I would suggest that it may be regarded as unprofessional. It's not what you see as the norm for medical practitioners. So my default instinct is that it will be seen as demeaning to the profession. But again, we could write to the board and say, this is what the practitioner intends doing. What is the board's view on it? On stationery and or on leaflets are often, and I encourage this, procedure information leaflets, condition leaflets that you give to your patients, which aid in the consent-taking process, which give them access to more information, which encourage them to read up on it and tell them where to find reputable sources of information, as opposed to Dr. Google, for example. If you've got your practice branding on that, I think that that's absolutely fine. I have no difficulty with that, in the same way that you have your practice branding on your consent form, which contains a lot of the similar information. But make sure that the pamphlet or the leaflet is what it says it is, information sheet. It must then be relevant to what that patient needs by information, and mustn't include, this is my 9,000, this operation, and that sort of, because strictly speaking, the information to be given to the patient is the generic stuff about the condition and risks, complications, benefits, etc. Yeah.
Thanks. Here's a quick example just for your comments. The scenario says a new hospital opens in a city, let's call it Pretoria, and it advertises that they've chosen doctors that are the best in Pretoria. Is that acceptable?
No, I don't think so, because that's a form of comparative advertising. So number one, I think there might be a problem with the advertising standards regulatory board, as they're now called. I still thought they were the Advertising Standards Authority, but that was apparently liquidated in 2018. Anyway, there's now the ASRB, and I know that one of the things which is considered verboten by the ASRB would be comparative advertising. So that's the first issue. The second issue is that fact I don't think is objectively demonstrable. So if it cannot be demonstrated objectively, how can it be true? Which is the test for that. And thirdly, it casts aspersions on the probity and skill of every other practitioner, because they are by implication not as good. And that would, in my view, be a transgression of the ethical rule against, I think is it Rule 12, JP, in booklet 2, something like that. which says that you shall not cast aspersions on the probity, skill, etc. of your colleagues. So I think that will be regarded as unprofessional. Alex, there was an interesting question. Sorry, an interesting question which popped up on the Q&A now live. It's the one about the impersonation of a doctor. And I think we just need to, there seems to be a bit of a misconception there, so maybe we can have a discussion about it, if that's okay.
Yeah, please.
Yeah. So the question is, would impersonating a doctor, that is a bogus doctor, also be dealt with in the same way as where a doctor would advertise illegally by the HPCSA? So a couple of things to understand, and some of this might be surprising. Number one, the HPCSA has no jurisdiction over bogus doctors. None whatsoever. And the reason for that is as obvious as the nose on my face. It's because they are not registered practitioners. The HPCSA only has jurisdiction over registered practitioners. However, in terms of the HP Act, it's an offence to impersonate a doctor, which means it's a criminal offence. So the state has jurisdiction over the bogus doctor. So the HPCSA becomes the complainant to the South African Police Service, who then conveys the information concerning the crime to the National Prosecuting Authority, which is the arm of the state that deals with that. And they then authorize a warrant for the arrest of the bogus doctor, and he or she gets dealt with in terms of the criminal justice process. Okay. A doctor who advertises unethically is subject to the jurisdiction of the HPCSA, and it will have jurisdiction over him and be able to sanction him or her. But I can tell you now that the outcome of a finding of having acted unprofessionally by advertising unethically will be very different to the outcome of a bogus doctor being charged criminally for having impersonated a doctor. So I hope that distinction is clear.
Yes, thanks. So we tackle some on the live questions. So there's a question around the lecture sponsored by a company. I think JP did touch on that, and Ethel. So if I'm correct quickly, it's fine if you're sponsored as a speaker. That's probably fine and admissible, preferably declared. Or that was roughly the message. Am I right?
Yeah, and I think just as a precaution, make it clear at the beginning of the talk that I've been sponsored by this company to do this. This is what I'm receiving as an honorarium or whatever the case may be. And you will be aware that there are not only these products on the market, but there are others as well. And that's typically lectures in a professional setting, which is viewed different to marketing to the public because the setting is different.
Okay, thanks. One of the questions relate to Poppy, so it's a slight extension of the topic today. And really it says, the first real question, is it mandatory for a practice to be Poppy compliant? I think we know that is a yes, but it carries on to an extent of being guided by or subscribing to a professional attorney, including formal training of admin staff, getting a certificate as proof of compliance, and displaying the relevant documents in the practice and your practice website. So perhaps just an extension of the Poppy question. Yes, be Poppy compliant. Are all of those requirements necessary?
No, in theory, you could read and gain a proper understanding of the requirements of Poppy and what you need to do in order to be compliant at all times. They're quite comprehensive. There's no formal requirement of having to take formal legal advice. There is a requirement, well, let's put it this way, as the responsible party who will be processing personal information belonging to the data subjects, i.e. the patients, the buck stops with you insofar as concerns compliance with the Act. So if your staff are not being properly trained and told basic things like, don't leave the password to the computer stuck on a post-it note on the monitor, which then allows someone to access the patient records, or don't have loud conversations identifying Mr. Smith and his condition and whatever else of his information that you have available, while Mrs. Jones can hear it in the waiting room. And if there's a complaint to the information regulator or to the HPCSA about it, then unfortunately the practitioner who operates the practice as the responsible party will be held accountable. So it's advisable to get proper training. You don't need it from an attorney as such, but certainly someone who has competence and able to display competence in that regard. You need to have a privacy statement so that patients know how their data is going to be processed. You need to know what must be contained in your consent and new patient take-on forms in order to be able to process the information for all the purposes that you're going to use it. And often, I mean, we saw this in the beginning of POPI, the patient's next of kin information was given to tracing agents to find them after they failed to settle the doctor's bill. And the patient popped up and said, but I never gave you that information for that purpose. And it's problematic. So, yes, I think it is best to get advice from a professional, but it's certainly not a requirement of the Act.
Thanks. I'm aware certain societies and even our website has some guidance and some guidance lists on the POPI requirements. Thanks, Ethel. There's two questions, sort of extensions of each other from Gregory, and I'll take a bit of liberty just to rejig it slightly, but it starts or ends off with sort of Gregory's belief. So he says, my belief is that advertising per se is a bad idea and it makes us look like any other business looking for turnover rather than a professional who is sought out by the patient, who is deserving of understanding in the event of a complication despite our best efforts. I think that if the first initiation of the doctor-patient relationship is by the patient rather than us, it makes a difference, and this is in the context of medical legal claims. So the real question is there any research comparing the rate of advertising with the rate of medical legal complaints in different countries, or research comparing the rates of complaints against doctors who advertise compared to those who do not? Or JP or Ethel, are you aware of anything of that nature?
Not aware of any research on that.
No, me neither. What I will say is this. I'm desperately scrambling through my memory bank to think of a case that I've done where part of the patient's gripe was I read in an advert that the doctor had said X, Y, and Z, or he falsely promised that this could be delivered and it was not. And I can't think of an example. So in my own practice, I don't keep a tally, but it's hundreds, if not thousands of these cases. I haven't seen it once. But that, I think, is also a product of there not being a lot of advertising. It's certainly, let me put it this way, I see more advertisements for lawyers than I do for doctors. So I think the level of our advertisements is still low, but even though it's low, our rate of claims, as you guys in the indemnity business will know, has gone up both in terms of number and value over the years steadily. So I don't know that there's a correlation between the two, certainly not in the South African setting. But I understand the sentiment.
Yeah.
I understand the sentiment that, you know, if the first initiation is from the patient and it's on a professional level only, yeah, I get that.
But I was going to make the point that in some instances, patients don't always have the information or the knowledge about, let's say, a particular condition. So yes, they might not be, it might not be the best thing for practitioners to be out there putting themselves in the limelight and advertising their services and awaiting patients to come to you. But in a lot of cases, that information, unless you put it out there, won't necessarily be known. So I'm thinking of some practitioners who have very good websites where they share some details about, normal patient education, uh, some details about, probabilities of a particular outcome following this particular modality. And, that's not necessarily known to a patient. So you might not necessarily know which practitioner to go to, or I have this condition. Sometimes advertising, and obviously what we're talking about here is, if I understand correctly, is responsible advertising in an ethical way, not the sensationalist advertising that we were talking about. But if it's done responsibly, I think it's good. I think it helps patients a lot identify what the conditions are, understand what treatment options there are available, and even just directing them to the appropriate people. So it's one of those things where I agree with the sentiment, but I do think that responsible, ethical advertising is warranted.
Thanks. I'm wary of the time, so maybe a quick question or two around let's just look at one more, or a few more, and then we'll try to wrap it up. What advice can you give a patient contacting a doctor on WhatsApp for medical advice?
Take it offline. I would say to the patient, in order for me to be of assistance to you and to render the service that you require, I would need to perform a thorough examination of you and an evaluation, which may involve additional specialist investigations. So it's not something that I can necessarily make a diagnosis of on this platform, and I invite you to come and see me for a consultation, or see me or another neurologist or whatever I am for specific advice.
I often tell doctors, if you're not comfortable with a particular form of communication, like WhatsApp, for example, then be upfront about that and mention it to them so that you aren't contacted by them on WhatsApp, for example. But if you are, then it's fine. I think it also depends on the patient. I mean, if it's the first time you're seeing this patient, then obviously WhatsApp communication for advice wouldn't be appropriate. But if it's a known patient and it's more of a follow-up question, then I suppose in those circumstances it would be fine to give them advice. But sort of as the general rule, I think as Ethel suggested, take it offline, invite them to your rooms. You can have a discussion about general things, but when it comes to very specific information and advice, take it offline.
Yeah, JP, that's very important. There's a distinct difference between the existing patient and a new patient and the follow-up setting. Alex, I know we've got to go, but there's one question that I think I need to answer so that I can sleep better this evening. It comes from Anonymous, and it says, are you allowed to publish your fees for consultation and some procedures on your website? Yes, you can, but you must ask yourself another question. Is it a good idea? I can think of a number of reasons why it's not a good idea. If you don't keep it up to date and you subsequently increase your fees, but you don't update the website, you're going to have a problem with the patient when they get the new bill. Secondly, if you're talking about procedures and you quote the code and your fee for that particular procedure, and the patient then comes and needs to have that procedure and wants to undergo it, and then they finally get the bill, but now there's modifiers on the invoice for their BMI, for it being an emergency or not an elective procedure, you're going to have a problem with that patient in terms of informed financial consent. Because on your website, you said that cost 10 Rand. And now suddenly the patient's got a bill for 20 Rand. So my view, you don't need to do that. So why do it?
Thanks. Could I just extend that? It comes from another question. I'm just trying to find it. Could you also, for instance, add that you are on a specialist network of a medical aid?
Yeah.
Could you advertise that?
Yeah. You can say who you contracted to, and as many doctors do, they specifically point out that they're not contracted to any schemes. and that all patients are treated on a private basis. Now, if the HPCSA, I know, requires you to inform patients of that so that they don't get surprises, then you can't very well be criticized for informing them equally that you are contracted to your scheme.
Yeah. Okay, Ethel, JP, I know there's some more questions. I'm wary of the time. Do you think we should wrap it up? I'm scanning through. I think some have been covered in your presentations. Others we could perhaps attend directly outside of the webinar. Are you comfortable with that?
Yeah, very comfortable. I'm sure JP and the team could handle that.
Yeah, I'm sure we can. Okay, with that, thank you very much, Ethel, for your time. Thank you very much, JP, for your time. Thank you all to the participants. As you exit now, when we end, there'll be a quick survey. Please do give us feedback, give us guidance, help us with future topics and webinars. It will be on the website, this as well as the HPCSA booklets also on the website if you want a quick access and find them there. Thank you very much. Have a good evening. All the best. Cheerio.
Thanks, you do. Good night.
Thanks. Yeah.
Good night.
Bye.